Good afternoon, everyone present here. I, Huma Khan, Assistant Professor, Faculty of Law, Integral University. Welcome to Interdisciplinary Faculty Development Program on Emerging Trends and in Administration of Criminal Justice and Forensic Science. Today we are going to begin technical session second as per the second module of Faculty Development Program. Our today's topic is Criminal Court and Prosecution Stages and Different Courts. I warmly welcome our today's resource person, Dr. Shobha Gulati, ma'am. Ma'am is working as an associate professor with the School of Law, Lovely Professional University, Punjab. She has a total teaching experience of 9 years. Ma'am has pursued LLB and LLM from Kurukshetra University, Kurukshetra, and PhD from Guru Nanak Dev University, Amritsar. She has authored one book, edited and has 17 research publications in various journals and various journals UGC care listed in Scopus Index as well. To her credit, ma'am has participated and presented papers in more than 25 national and international conferences, seminars, and workshops as well. Ma'am is a crusader for women's rights and delivered guest lectures at Punjab Police Academy, Philor, on gender sensitization and crime against women. Now I would like to welcome ma'am for today's session. Over to you, ma'am. Hope I am audible.
Hello, good afternoon. Am I audible? Ma'am, if you could please confirm, am I audible? Ma'am, am I audible?
Yes, ma'am, you are audible.
Okay. I just wanted to confirm if it's okay. And ma'am, are the slides visible?
These slides are visible or not visible? Yes, ma'am. Now your slides are visible.
Okay. Thank you so much, ma'am. Good afternoon to all of you, and sorry for the delay. There was this technical error in joining, because of which this got delayed. So today's session is on criminal courts and prosecution stages and different courts in India. See, as far as criminal law is concerned, we all know that India has a well-established statutory, administrative, and judicial framework for criminal trials. And Indian penal laws are governed primarily by three basic laws, which are the Code of Criminal Procedure, the Indian Penal Code, and the Indian Evidence Act. And it is very rare that you could read any of these acts in isolation. It is a well-knit tandem with which all these three laws have to be studied and dealt as far as when it comes to criminal law. Before we start on with the criminal trials in India, like as the session goes, it is important to discuss the hierarchy of criminal courts that is there in India. When we say of hierarchy of criminal courts, if we start from the top, we know the apex court, which oversees the criminal cases, is the Supreme Court. Then we have the high courts, and then the session court within the district. Within the session court, there are other various courts which will be in subordination to the sessions court. It could be sessions judges, additional session judges, then assistant session judges are there. CGM, Chief Judicial Magistrates are there. In metropolitan areas, these are also called as Metropolitan Magistrate, and within the Chief Judicial Magistrates and Chief Metropolitan Magistrates, again we have further classification where you will find the Class 1 judges, the Class 1 magistrates and Class 2 magistrates. We'll discuss their powers, how they work in detail. As far as the Supreme Court is concerned, we all know that it is the apex body governing all the courts in India, and it is constituted under Article 124 of the Constitution, directly deriving its force from the Constitution. Similarly, high courts are also constituted directly under the Constitution, Article 214. And it is also this, that when we see that doctrine of precedence is followed in India, another article which has to be read in tandem is Article 141, and which says that the Supreme Court decisions are binding on all the courts within the territory of India, be it the high courts or be it the subordinate judiciary. Now we will here in collaboration, because we are going to discuss criminal trials, we will be more savvy with the constitution of criminal courts at the sessions level. And we see that within the sessions court, as I've already said, within the sessions court, we have this Chief Judicial Magistrate, and then the Magistrate Class 1 and the Magistrate Class 2, and then also Executive Magistrates. So in metropolitan areas, these will be called as Chief Metropolitan Magistrate or Metropolitan Magistrate, MM, CMM. In any district within a high court, we know that the apex court is the court of session. The highest court in any district or session will be the court of session. I've seen even many of the senior faculties many a time calling it as district court. So we being legal luminaries, we should not make this mistake. Whenever we are discussing anything on criminal, we should be very specific and use the nomenclature session court and not district court. So when we say court of session, from where court of session is formed, it is basically section 9 of CRPC, and in fact section 9, 10, 11 up to section 20 of CRPC, you will find that the force, the powers of session court, the powers of assistant session court, additional session court, then the CGM, and then the other lower judiciary will be governed by these all provisions which are directly given in CRPC. As far as the High Court and Supreme Court was concerned, they are constituted directly by the Constitution of India. Okay, section 9 of CRPC, it speaks of session court. It empowers the state government to establish session court, and such court would be presided over by a judge which is appointed by the High. So session judges are appointed by the High Courts. Along with sessions judges, there can be additional and assistant session judges as well, with little bit of deviation in differences in powers of the additional and assistant session judges. But as far as the appointment of the additional and session judges are concerned, like sessions judges, additional and session judges are also appointed by the high courts to exercise their jurisdiction in any courts of session. And where do the session courts, where are the session court formed? It is totally the discretion of the High Court to divide its entire district into various territorial jurisdiction, within which the district and session courts will be constituted directly under the orders of the particular high courts. Then section 10 of CRPC says that assistant session judges are answerable directly to the sessions judges. When we speak of powers of session judges, or when we are going to discuss in the further slides the powers of session judges or the powers of additional session judges, you will find more or less the powers of additional session judges are same as that of session judges. But as far as assistant session judges are concerned, less of powers are being exercised by the assistant sessions judges, and they are directly answerable to the session judge as per section 10 of CRPC. Court of Judicial Magistrate, Section 11 of CRPC states that in every district not being a metropolitan area, the state government, after consultation with the High Court, shall establish judicial magistrates of first class and second class. And likewise, we see that the vacancies of judicial this judges or civil judges come judicial magistrate of class 2 are advertised. So whenever there are vacancy selections are being done, it is usually for the class 2 judges. They are after that elevated to class 1 judges, and the next hierarchy would be CGM or the metropolitan magistrate. And if in the opinion of the High Court it is important to empower any of the class 2 judges with the powers of class 1 judges, that could be done directly under the orders of the High Court, or even the power lies with the sessions judge to give more power to the lowest level judicial officers, which are class 2 magistrates or class 1 magistrates. Their powers could be increased of class 2 magistrate, powers of class 1 could also be given. Chief Judicial Magistrate and Additional Chief Magistrate are Judicial Magistrate are appointed by the provision of Section 12 of CRPC. And the High Court is also empowered to designate Judicial Magistrate of first class as CGM. Like I said that class 2 powers, class 1 powers can be given to class 2 powers, class 2 Judicial Magistrate. Similarly, when we speak of Chief Judicial Magistrates, the powers could also be given by the special order of the High Court to class 1 magistrates. If and when the situation requires, or when there is no CGM, then powers could be given to the officers below by the High Court. Then in addition to these Chief Judicial Magistrate and Magistrate of class 2 and class 1, there could be, I have not included in the slide, but yes, I've mentioned it in the second point, there could be appointment of Special Judicial Magistrate as well, whenever requirement is there of for some particular cases or for some specific reasons that there is need of some Special Judicial Magistrate. In addition to the ordinarily sitting class 2 or class 1 and the CGM, they could also be appointed. And it is you will see that Chief Judicial Magistrate basically work as head of the departments of the courts below, which are class 2 courts or class 1 courts, and you will see that the territorial jurisdiction of the class 1 magistrates and class 2 magistrates are basically decided by the Chief Judicial Magistrate. So they will operate as the head of the department. The Chief Judicial Magistrate basically oversee the administrative work of the courts, and also in addition to that they have special powers to see some special cases. We are going to discuss what all special powers they do enjoy, and they also have the task of dividing the territorial jurisdiction of class 2 magistrate and class 1 magistrate as well. Now, when we come to the powers of various courts, what will be the powers of Supreme Court, or what are the powers of the High Court, or what are the powers which have been bestowed upon the Sessions Court, or when I said that lesser powers will be there on the assistant sessions judges, or what powers are there with the other CGM and other magistrates. So by default, without saying it goes that Supreme Court, being the apex court, enjoys all the powers. They can give verdict, they can pronounce judgment of any order to the highest order. Having said that, I hope many of you, if you correlate it with the Constitution of India, many of you must be aware that all the cases from High Court, criminal cases, and whenever I'm talking of cases, for this section, I am more specific towards the criminal side. So all the cases from High Court do not go to the Supreme Court. If we read Article 132, 133, 134 of the Constitution, we know that as a matter of right, you can approach the Supreme Court in criminal trials only in specific cases, or those 2-3 instances wherein some judgments, some important things were there, maybe the the accused was let free by the lower court, and then in the verdict of the higher court there was this death penalty which has been imposed upon. So there is drastic change in the decision of the sessions judge and the high court, wherein there is something fishy is found, then as a matter of right you can move directly to Supreme Court. But as a matter of right, cases, criminal cases, civil cases, there is a again there is, you will see most of the civil cases are finished at the level of high courts only. Not all the cases go to the Supreme Court. Even in criminal cases, as a matter of right, you cannot every time approach the Supreme Court. As a matter of fact, only in 2-3 exception circumstances which have been given in the Constitution, you can approach the Supreme Court. Otherwise, if you want to approach the Supreme Court, you need a certificate from the High Court. As far as the power of High Court are concerned, again, High Court is empowered to pass any kind of sentence. In its judgment, High Court can even give award death penalty or life imprisonment or imprisonment of any other sort, or only penalty. Any kind of punishment could be given by the High Court, which is authorized by law. As far as the powers of sessions judges are concerned, I told you that more or less sessions judges and additional sessions judges enjoy the same powers. So when it comes to the highest officers, highest judicial officers of any district or any session, you will find that sessions and additional session judges have also been empowered, like High Court, to pass any kind of sentence. So a sessions judge can pass even a death sentence. He can pass, give this life imprisonment. He can impose any penalty. He can impose any kind of within the prescribed limits of law. Obviously, it has to be read in tandem. I told you it cannot be read in isolation at any time. You have to always read CRPC, read with IPC, and so whatever powers they do have within the boundages of IPC, they can give any kind of punishment. Having said that, if a sessions court pronounces a death penalty, then in that case, that death penalty is going to be affirmed, or you can say it is going to be confirmed by that particular High Court. So sessions judge can pass any sentence, even death sentence, but whenever they're going to pass any death sentence, then it has to be confirmed. The file will be sent to the High Court, from where confirmation orders will come, and then the death sentence will become operative. As far as the assistant sessions judges are concerned, assistant session judges have the authority to pass any sentence of imprisonment up to 10 years. They have the authority to pass any sentence other than death sentence or life imprisonment. They cannot give death sentence or life imprisonment. Up to 10 years of punishment they could easily give, and in terms of penalty, there is no limit defined for the assistant session judges. So any kind of penalty in the form of fine could be imposed upon by the assistant session judges. So you see, when it comes to assistant, they have basically certain lesser powers than the additional sessions judges, or what the sessions judges enjoy. Similarly, in the lower judiciary, you will find the hierarchy, when it comes down, powers will also decrease. Yes. Sentences passed by magistrate. What kind of sentences can be passed by a magistrate? When it comes to Chief Judicial Magistrate, Section 29 of CRPC comes into picture, and it equivocally says that a Chief Judicial Magistrate, or if you draw an oblique in a metropolitan area, you could also say Chief Metropolitan Magistrate, can pass any sentence of imprisonment, but not up to 7 years, but not death penalty cannot be given by Chief Judicial Magistrate, and even life imprisonment cannot be awarded. And as far as Class 1 judges are concerned, they can pass a sentence of imprisonment for a term less than 3 years. So up to 3 years they can pass, and fine up to 10,000 rupees, or both can be given. So for judicial magistrate of Class 1 and Class 2, you will find very less powers have been given. Class 1 officers can pass imprisonment of up to 3 years, and class 2 officers can pass imprisonment of up to 1 year. In terms of fine also, their limits have been well defined. Class 1 officers can give levy fine of up to 10,000 rupees, and class 2 officers can levy fine or penalty of up to 5,000 rupees. So you see, whenever the appointments are done for the judicial officers, usually they are done for class 2 officers, and they can pass sentence of up to 1 year only or 5,000 rupees. But you see, as a phenomena, what happens is, practically, because very less powers in terms of punishment of up to 1 year, or you could say, for the fine cap of 5,000 is there. So when it comes to practical implementation in the courts, many a times it has been found that it becomes very difficult for the for the class 2 magistrate to pass sentence. In that case, many a times you will see the high court by this orders sometimes give the powers of first class magistrates to class 2 magistrate as well, so that on account of this limit of imprisonment or penalty is concerned, the hands of the class 2 officers are not tied up too strictly. So you will see, usually by an order, the class 2 judges, when they are appointed, or later by this notification, they are being given the powers of class 1 magistrates. So this was all about the basic things of the constitution of criminal courts, the hierarchy as it goes from top to bottom, starting from Supreme Court to the class 2 magistrates, and what kind of powers they do enjoy. So more or less you've seen, obviously Supreme Court will have all the powers, High Court also has all the powers, Sessions judges also have all the powers, barring one exception, which is confirmation of death sentence by the High Court. Assistant session judges will have little less power, and then less powers have been given to CGM, class 2 magistrate, and class 1 magistrate. So this is how the hierarchy goes. As far as the process of trial of criminal cases in India is concerned, I told you that you can never read only one of these acts in isolation. It is always, when you are talking about the process of trial of criminal cases in India, all the acts have to be read with each other. And more or less, you maybe yesterday you had a session on this powers of the police officers. You will see that whenever a crime is committed, there are three kind of stages in which this could be divided: pre-trial, trial stage, and post-trial stage. This is how it basically goes. As far as the CRPC is concerned, we know that CRPC is a comprehensive and exhaustive procedural law for conducting criminal trials in India. So it might be with regard to collection of evidence. Whenever we say that exhaustive matters with regard to collection of evidence is concerned, or maybe with regard to, you could say, examination of witnesses is there, interrogation of the accused is there, taking of their statements under section accused under 313 is concerned, or arrest is concerned, safeguards are concerned, and procedure to be adopted by the police, and as well as the procedure to be adopted by the courts, bail, process of criminal trial, everything has been elaborately dealt with in CRPC, including the method of conviction and the rights of even the accused in a fair trial, what rights the accused enjoys. So you will see in CRPC, in different chapters, all these things have been elaborately dealt with. The procedure for a criminal trial in India is primarily, except as provided, governed by CRPC, and you will see that IPC is the primary penal law of India, the substantive part of criminal law, which is applicable to all offences, except that may be provided under any other law. So uh, it is also important to note that India follows the adversarial system, wherein generally the onus of proof of proving that a crime has been committed will always lie on the prosecution, will lie on the state, the prosecution, to prove the case against the accused. So we generally see that the accused is not presumed to be guilty unless and until beyond reasonable doubt his guilt has been proved by the prosecution. And generally, you will see that accused is presumed to be innocent, barring 2, 3, 4, 5 exceptional circumstances wherein in IPC the accused has to, the onus of proof is shifted to the accused. Otherwise, he is always presumed to be innocent. India has developed criminal jurisprudence and prosecution system supported by judicial precedents. But there may be certain issues or concerns relating to execution of the same by police and implementation by judiciary. So though we have a well-knit structure, but we find various problems being creeping in, which the police officers encounter, and even the judicial magistrates or the officers of courts do witness many kind of practical, you could see lacunas while implementing the judgments. And I have a whole good lot of friends who are into judiciary, and I've seen them telling many a times that though they have powers, but when it comes to the implementation part, sometimes there are lacunas due to which they are not able to take strict action against the accused person. So we will discuss a little bit of lacunas also, and how those lacunas in the trial system could be overcome. And we will see that as far as the lacunas are concerned, you will always find that the high courts and the Supreme Court, which are the apex court in India, they have been very vigilant enough. They have been very proactive in guarding the rights of the accused. And even Article 21 of the Constitution has of India, you will find in various cases, in various leading judgments, has been interpreted in such a manner that a highly, you could say, dynamic approach is being given to protect the rights of the citizens by incorporating the principles of natural justice. So rights of even the accused are protected many a times. There have been cases wherein the rights of the prisoners have been protected, rights of the citizens have been protected. So as far as possible, complete justice should prevail is what the purpose of criminal law system in India is concerned. If we want to proceed with the criminal trials in India, there are certain basic things which I've included in the slide. I think yes. To appreciate the process of Indian criminal law, it is necessary to understand following some important terminology, though we might be aware of, but might be there are some people in this you could say a seminar or session wherein who are not that much savvy to criminal trials. So it is very important to understand the basic things for any criminal trial, without which you cannot proceed with understanding the complete trials. So first you could say is what is a bailable offence. So bailable offence means an offence which has been obviously categorized as bailable, and in such offence bail can be claimed subject to certain conditions as a matter of right. So in bailable offences, you can take bail from the police station or from the court as a matter of right. And you will find in all the bailable offences, even the police officers directly have been empowered to grant bail. And in non-bailable offences, what happens is that many of the people who are not from legal background, they say they treated that in non-bailable offences bail will not be given. That is not the scenario. Non-bailable offences are those offences in which you cannot take bail as a matter of right. You cannot claim bail as a matter of right, but you can in fact get bail by the orders of a competent court. So it is through court orders that you have to get the bail. So you have to prove your special circumstances, wherein you have to prove to the court, to the subjective satisfaction of the court, that yes, these are the given set of circumstances and I will be abiding by the orders of the court, and therefore bail should be granted to me. In such cases, the accused can apply for grant of bail under section 437 and 439 of CRPC. So when we say that the bail in a non-bailable offence, you will get bail, a non-bailable offence through the orders of the court, the point here, the noteworthy point here is that the complete discretion whether to grant bail or not to grant bail will lie with the court officer, which is the magistrate concerned, the judicial magistrate concerned. And it has been mandated by the Supreme Court of India that bail and not jail should be governing and guiding principle. So though rights have been granted to the judicial officers to grant bail under section 437 and 439 of CRPC, but at the same time the court officers have also been mandated that they should be in favor of granting bail and not jail should be the criteria, because see, at the first instance the accused is presumed to be innocent, so there is no point in keeping the accused behind the bars even in non-bailable offences. If the court finds it fit that they are going to cooperate with the court, and whenever they are being called off, if they are complying with the orders of the court, there is no point in keeping the accused in prison pending his trial. Then the third important thing which is there is anticipatory bail, which is very many a times disputed that they should not be done. So under section 438, 437 and 439 are the non-bailable, for non-bailable offences you can take bail. Under this, 438 speaks of anticipatory bail, which means that a person who is apprehending, wherein there is an apprehension that I might be arrested for maybe there are some wrong accusation which might be levied on me for committing some offense, I might be arrested. So that person can apply before a competent court for an anticipatory bail, and that very order of the court will direct the police to immediately release a person on bail if there is this event of arrest, in case that person is about to be arrested because he has already taken anticipatory bail. So it will be in the form of direction to the police officer that in case this person is actually arrested, let go that person on bail. However, the grant of anticipatory bail is discretionary and dependent on the nature and gravity of acquisitions. So it is not that in every case anticipatory bail will be granted. The court will consider that what are the accusation of which the person is apprehending arrest, what are the ground, what are the circumstances, and if they see that bail is the proper thing to do, then only they will grant bail. So having said that, bail and not jail is the rule, but wherever required to impart complete justice, there is no stopping the officers from refusing to grant bail in heinous crimes, or you could say some other set of circumstances where there is a chance that the accused might flee off. So in those circumstances, there is nobody stopping the courts from giving this, from denying bail to the accused person. Then the next important definition to discuss here goes of cognizable offense. Now, why we are discussing all this bailable, non-bailable is that I'll come to it in the next slide, and I'll tell you why we are discussing all these things. Now, cognizable offense or a cognizable case, you will find mention of it in section 2 of CRPC. It is an offense or a case in which a police officer can arrest without a warrant. So, cognizable offenses are basically serious offenses in which the police officers can arrest without a warrant. No orders from the court are needed. Warrant are issued by the court, so no court orders are needed to arrest a person in case of heinous crime. Why no court orders are needed? Because if the police officer are going to wait for the court orders, by that time the evidence will be destroyed, accused will flee off, and there is no point of providing justice to the parties. So in cognizable offences, you will see that police can arrest without a warrant. As far as non-cognizable offences are concerned, you will find these offences to be of less graver nature, and these are defined in section 2I of CRPC, and a police officer has authority to has no authority to arrest a person without a warrant in this cognizable offences. So if it's not a serious offence, and generally we will find mention that those offences in which imprisonment is of less than 3 years, they are non-cognizable offences, and in which there is punishment is of more than 3 years, that they are cognizable offences in which the police can arrest a person without any warrant. Then the next important thing, which I do not think needs much elaboration, is the FIR, which is first investigation report. It is formal record of the complaint by police in case of commission of cognizable offence. And you could see the filing of FIR as we say, first information report is the first instance wherein the police is sensitized to take action uh, on the complaint which has been given, which has been received by the police officer. So it is in fact the first step which will sensitize the police and throw open the process of investigation by the police officer. And then you will see. Okay, and then we see that why we have discussed that whether it is a bailable offense or a non-bailable offense or cognizable offense or non-cognizable offense. Why it becomes important is that whenever any crime is committed, so first of all we will refer to IPC. In IPC, in Schedule 1, you will see in Table 2 of Schedule 1 of the CRPC, also in IPC, you will find a complete table. If you say that, okay, this dacoity has been committed, so for dacoity, what is the punishment, whether dacoity is a bailable offense or non-bailable offense, it is a non-bailable offense, whether it is cognizable or non-cognizable offense, so it is a non-cognizable offense. And in the last column, you will find a mention who is going to try this case. The trial will be done by which authority, whether it is going to be class 2 judge who can, class 2 magistrate, sorry, who can try the offense, or class 1 magistrate, or whether it is triable by CGM or sessions court. So whenever an offense is committed, okay, so first thing to see that who is going to try the case will depend upon what has been mentioned in the last column of the schedule. So we need to check that out first. So basically what we will find is that I have told you that offences punishable with imprisonment of less than 3 years, you will find them to be non-cognizable and bailable offences, wherein bail will be given, can be given directly as a matter of right by the police officer only. And you will generally find, usually that you will find that the offences which are punishable with imprisonment for more than 3 years, more than 3 years means they are serious or cognizable offences, and you will find them usually to be non-bailable offences. If you want to take bail in the serious or cognizable offences, then it has to be done through the order of the court. Let me take you to the next slide. Okay, yes. So in criminal investigation process and prosecution mechanism in India, it can be started by in these following manners. So what could be done is that how this the criminal investigation process will be started is three basic things: on complaint or any knowledge of the commission of a cognizable offense of any police officer, even without the orders of a magistrate, can investigate the cognizable case. So whenever there is the police officer receives the information of commission of a cognizable offense, of a serious offense, then the police officer, without waiting for the orders of the magistrate, can proceed. Usually we will see that what happens is that whenever a crime is committed, first thing which we see is that, which you must have discussed in the previous session, maybe yesterday when you were discussing the powers of the police officer. The first thing is that whenever a crime is committed, first FIR is lodged under section 154 of any cognizable offense. Okay, so if there is a serious offense, non-bailable offense, obviously I've already told you that these are the incognizable offenses in section 156(1). Uh, the waiting for the orders of this court orders is not necessary, and the police can directly proceed to the crime scene and start their investigation without any formal orders. Because if they are going to wait for the formal orders on the crime scene, evidence will be destroyed, accused will flee off, and there are a lot of negative repercussions which will have to be overseen. So that time cannot be given to the accused to destroy all the evidences. So in this case, section 156(1) will come into picture, and the police officer will directly have the power to proceed and take over the case. Then you find, in case of failure or inaction of a police officer to investigate a cognizable offense, what will happen is that many a times what will happen is that if the police officer is not investigating a cognizable offense, so what could be done? And many a time you will see that people say that our FIR is not being lodged by the police officer, or they are not taking any action, or they've been bribed. So what could we do? So a criminal complaint can be filed before a magistrate under section 190 of CRPC, wherein, and you will see that in section 190 of CRPC, the magistrate will take cognizance of the offence, and then direct, the magistrate can himself take cognizance of the case and do the inquiry himself, or in the alternative, magistrate can also direct the police officer to register the FIR and to investigate the offence. So wherein there is inactivity on the part of the, or you could say, passiveness on the part of the police officer, so there is nothing to be afraid of. A resort is given again in CRPC. Directly magistrate could be approached. Magistrate will take cognizance of the offence. So magistrate can proceed to inquire the offence. You will also see that many a times even the faculties of law, I've seen them making grave mistakes when they say that magistrate is conducting investigation. So we have to be very specific about the terminology we use, because obviously students are impacted by the terminology which we use. So whenever we use the word magistrate, inquiry is conducted by the magistrate and the police officer conducts the investigation. So herein, in this case, wherein inaction is there on the part of the police officer, magistrate will either go on to telling his team or inquiring the case himself, or ordering the police officer under section 156 subclause 3 of CRPC, wherein he will direct the police officer that register the FIR and proceed with the investigation of the case. These are the circumstances. Point A and point B are in case of this cognizable offences, serious offences. So in serious offences, without wasting any time, police is directly approaching the crime scene, or if they are inactive, then under the orders of the court, under the orders of the magistrate empowered to take cognizance of the offence, they have to register the FIR and uh, they have to proceed with the investigation. If they do not, or in the alternative, they can also inquire the case themselves. So these two are in the case of cognizable offences. In case of non-cognizable offences, police is not obliged. There is, in non-cognizable offences where I've told you that punishment is of less than 3 years, in those cases, the police officer is not under any mandate or obligation to investigate the judicial process himself, and this process can be started by filing a criminal complaint before the competent court under section 190. So first, in non-cognizable cases, first the information will be given to the magistrate. He will take cognizance under section 190, and then he will tell them, the officer, police officer, to proceed with the investigation howsoever required. So mandate is in cognizable offences, in serious offences, not in non-cognizable offences. So you will find that whenever there is this commission of a crime, whenever a crime is reported, whenever a crime is reported, or the magistrate of their own suo motu action have come to know that there is a crime which has been committed. So what they have to usually see is that first, whether it is a cognizable or non-cognizable offense. Then after that, what will be done is that when the person who is accused is arrested by the police officer, so first of all, whether it is a cognizable offense, non-cognizable offense, that will be checked. If it is a cognizable offense, obviously the police will be sensitized directly. If it is a non-cognizable offense, first cognizance will be taken by the magistrate, and then the police will be directed to do their task. And once they are in the process of doing their task, if there is any accused person who is arrested, the first thing is that the accused will be brought before the magistrate. Yes, the accused is duty mandated to be brought before the magistrate within 24 hours is arrest, excluding the time of his commuting, or you could say his transportation is concerned. And when this accused person is brought before the court, we all know that there are various rights which are being given to the accused person as well. So it is his right to be informed on what pretext he has been arrested, what accusations have been levied upon him. So those safeguards have to be kept in mind. And once the person has been produced, after that the investigation will be started. Investigation has already been sensitized by the police officer on the entire thing will take place. Collection of evidences will be there. Whatever statements are by the maybe any persons are there, that will be recorded. And whatever powers the calling of witnesses will be done by the police officer. And in the end, the investigation by the police officer will be completed. Once the police has completed their part of investigation, next what they will do is, under section 173, they will file a charge sheet with the judicial magistrate. Now I often see that again people commit mistake of charging of charge sheet and framing of charges are concerned. As far as this filing of charge sheet by a police officer is concerned, it is the net result of investigation. So it is something which is related to pre-trial. This pre-trial stage is there. So whenever there is an offense, machinery sensitized, investigation will take place. After the investigation, police officer are mandated to submit their charge sheet to the magistrate. It is now that the magistrate will actually start the work of the magistrate will start from here. And when the charge sheet is presented, till this time there is nothing to do with the framing of charges, nothing at all to do with framing of charges. Framing is of charges is a stage which has to be done by the court only. No role of police is there. Police can only file the charge sheet. Later on, it is for the magistrate to check that whatever the charge sheet has been filed by the police, whether it is correct or not. So many a times you will find there are police officers who do not have much knowledge, so they will include maybe 10 sections. They will club 7 or 8 or 10 sections. Now it is ultimately the responsibility of the magistrate to check which all charges which have been filed in the charge sheet by the police officer, which all needs to be deleted. If any changes have to be there, what all charges have to be framed against the accused after hearing the accused under section 313 of CRPC. And a little bit of this primary this is concerned, inquiry is concerned, the court will proceed with framing of charges. So filing of charge sheet, framing of charges we're going to come later on. But there is a whole lot of difference between filing of charge sheet and framing of charges is concerned. So once the charge sheet has been filed, then will come the process of the you see the court process will be started. And you see that various criminal trials have been provided by law in India. I could check. So when we come to the trial stage, we will see that commencement of trial will be done. So there are various stages of criminal trials in India. These could be broadly divided as you could say that there are these warrant trials. We have this summary trials. We have the summons trials. There are also sessions trials which are heard before the sessions court. Sessions court have their very different procedures. I'm going to come to that. And what warrant trials are there? Warrant trials are as provided under section 2 X of CRPC. It is a trial when an offence is punishable with imprisonment for 2 or more years. So in that case, warrant trial will start. So if there is an accusation against a person that he has committed a crime for which the penalty or which the punishment is of more than 2 years or up to life imprisonment or death, then warrant trial will take place. If the accusation, the person is accused of a crime for which offence he is punishable with less than 2 years, then in that case the summons trial will take place. So there is a difference in warrant trials. There is a little bit of difference in warrant trial and in sessions, this warrant trial and summon trials. And you will find another thing which is there is summary trials, wherein summarily the cases are tried. So different trials we will have a look at. First will be sessions trial, then warrant trials wherein offence the punishment is of more than 2 years, If it is less than 2 years, it is going to be summons trial. Then we also have the summary trials. So for all these different kind of trials, you will find that in this different sections are there, more or less. While elaborately dealing with these processes in criminal trials, you will find that the basic rights of the accused and the prosecution both have been protected while framing these trial. Little bit of deviations have been given so as to fasten up the procedure in case of summary trials are concerned, or in sessions trial. I'll tell you that when do sessions trial take place. So depending upon the heinity of the crime, the trial process will change. So it is going to be much more harsher in sessions trial than that in summons or summary trial. So that you will find eventually. So in a sessions trial, you will find that uh, so whether it is going to be which trial. So what you could do is, so there may be many offenses like a murder cases there or rape cases there, which is not tried by any kind of judicial lower hierarchy magistrate, but it will be tried directly by the sessions court. And how will you come to know that it is a heinous crime of such a nature that it has to be tried by a session court? Everything you will find in this schedule 1. So when you're going to check the offense, if it is 302 murder case or 376 rape case, what you have to see last column of it, wherein it is written offenses trial by. Say for example, if it is 302 case murder case and the offense is trial by a sessions court, then what will happen is that you will see that again there is a lot of confusion with regard to trial stage. If it is a crime which is triable exclusively by a sessions court, then directly sessions court will not take cognizance of any offense. If it is a murder case, then the procedure will be, say for example, and I'm just going to take an example so as to make things more clear for you. So if it is a murder case and I've seen some murder happening in front of me, so what will be the normal course is that obviously there will be an FIR which will be lodged. Police will take its course. Investigation will be done. On the completion of the investigation, and even during when the investigation has taken place or when the accused has been arrested, you will see that though powers have been given to the police officer to directly investigate the case, but that does not mean that the police officers are not going to report back the case to their Ilaka magistrate or the magistrate concerned. So if it is a murder case within the vicinity, within particular territory, I've told you that CGM has given power to the lower judicial magistrate to see those cases. So if it is a murder case in the particular territory of a magistrate, obviously murder case, so directly the police officer will proceed on the crime scene. But after that, he is going to report the case to his magistrate concerned that okay, this crime has happened and I have proceeded with the investigation under my powers under section given to me under section 156 subclause 1 of CRPC, and I have proceeded with the investigation part, and I am in the middle of my investigation. Whenever there is going to be any accused who has been arrested, they will be brought before the magistrate concerned, before the same magistrate who is competent to take cognizance of that offense. So he will take first, magistrate will take cognizance. In every sessions trial, direct cognizance can never be taken by a sessions court. Always and always, cognizance will be first taken by a magistrate. Okay, and then meanwhile the police is doing his work, investigation. Once the police is finished with the investigation, they will file the charge sheet under section 173 with the magistrate. They are not going to file the charge sheet directly with the sessions court. So the all the basic work, procedural aspect, which is pre-trial, will be taken care of by the Ilaka magistrate or the territorial, whichever the magistrate has the jurisdiction to take over the case. So cognizance will be first taken by the magistrate once the charge sheet has been filed, and obviously the magistrate court knows that they are not competent to try the case. So they have taken cognizance means the knowledge of the crime is, they have taken the case in their hands. They know that there is a crime which exists. They have their knowledge, but adjudication, which is the trial, they cannot take the trial. Why? Because only sessions court is empowered by IPC. I told you CRPC cannot be read in isolation. So under IPC, sessions court is fit for to try the case. So once this cognizance has been taken by the magistrate, so he will club the FIR, copy any statements of the witnesses which had been called during investigation, any statements which were there, they will be clubbed. Any confessions which have been made maybe previously, or any other evidences which have been received till now during the course of investigation, all that filing will be punched, and in the section 209 of CRPC, that file will then be sent to the court of session for trial. So only the basic work will be done by a magistrate. He cannot proceed with the trial of the case. Trial is yet to begin. Trial will be done with the sessions court. So with the copies of whatever they have till now under section 207, 208, any FIR, any complaint report received, any FIR and complaint clubbed, whatever the work is there, they will be handed over under section 209, which is also, yes, I forgot to mention here that it is also known as committal of a case. So this committal of case will be then done to the sessions court, and then session court will begin the trial. Then also actual trial will not begin. I will tell you which is the stage when the trial begins. So till here the basic work was being done by a sessions court. Now in the session court, once this stage has been achieved, after that obviously the prosecution will be started. Let me check if I can look at this. Okay, not so. All right. So whenever this sessions trial will be initiated, so when will the trial begin? See, be it any kind of be it sessions trial, or be it warrant trial, or be it summons trial, or be it summary trials, there is always this misconception in the minds of students and as well as the faculties, that when is the trial going to begin. See, it is very important question to determine that actual trial will, see, till now the basic work of investigation, the basic paperwork was being going on. Actual trial will begin only once the charges have been framed. In CPC we call it as settlement of issues. In criminal law we call it as framing of charges. So I told you, I emphasized on charge sheet being filed by the police officer under section 173, and framing of charges by magistrate or session court is concerned. They are completely different thing. So framing of charges will be done by the magistrate after giving a chance to the accused, after prima facie hearing of the accused and the prosecution as well. So uh, the magistrate or the sessions court is then going to finally make up his mind that actually what charges have been levied upon by the accused, which I think, and I find that this is the most important task, uh, which is, or most important responsibility which the judges do shoulder, be it in the form of settlement of issues in civil cases or framing of charges in criminal cases. Why? Because framing of charges or settlement of issues is the edifice on which the rest of the trial is going to be based upon. So if there is any lacuna in the framing of charges or in settlement of issues, is there any lacuna, it will go down to the roots of the case. It will go down to the roots of the case, and the justice can never be meted out. So framing of charges is the most comprehensive, elaborate, you could say most dutiful thing which is required from any officer to be done. And once these issues have been settled, or you can say once these charges have been framed, from this stage onwards, trial will actually begin. Prior to this, all was the pre-trial phase. Prior to framing of charges, settlement of issues is concerned, all was the pre-trial phase. Now, actually, the trial will begin. Basically, what is the meaning of trial is that wherein trial, basically people often think that the moment you step into the court, trial begins. Never. This will never happen. Trial basically means adjudication of the case, wherein the judge in his judicial capacity starts applying his judicial mind. when he starts applying his judicial minds, when he starts calling the witnesses, taking his statements, when he calls the prosecution witness, when he hears the defense witness, when he hears the counsel of both the parties, when he gives a fair chance to the prosecution and the defense to present the case from their perspective, and every evidence they want to lead. They are free to lead every kind of evidence. And based on that evidence, based upon the hearing of the parties, seeking always keeping in mind the principles of natural justice, giving an equal opportunity of being heard to both the sides. And after that, the based upon those arguments of the counsel, and based upon the arguments of the counsel, and also based upon the evidences that have been taken, finally the judgment will be delivered. Finally, the judgment will be delivered. Sorry for the pause. All right, and finally the judgment will be delivered. So this entire process, which started after framing of charges, till the delivery of judgment, the delivering of judgment by the court is concerned, this entire is the trial stage. Before it was the pre-trial stage. So investigation part, the other part before the framing of charges, had it been an inquiry before this, before the pre-trial, all that prima facie inquiry, everything will form part of stage 1, which is pre-trial. Stage 2 is your trial stage, and stage 3 is your post-trial stage. Sorry. So if it is this a sessions trial, so once the file has been forwarded, file has been committed under section 209 of CRPC, now will begin the sessions trial. And when we say sessions trial, you will find section 238 to section 250 of CRPC, which contains the elaborate procedure which deals with sessions trial. All right. Yes. Okay. I'm sorry. Section 225 to section 225. This sessions trial will commence. So when we say that session trial will commence, and session trial has now commenced, so how will the sessions trial be commenced? So you will say that trial to be conducted by public prosecutor. So every criminal trial, session trial, will be conducted by a public prosecutor. In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. And you will find the next thing will be opening of case for prosecution will be there. So when the accused appears before the court, or when the accused is brought before the court in pursuance of the commitment of the case under section 209, as I have already told you, under section 209, the prosecutor or the prosecution shall open his case. So how will the prosecution open his case? Is by describing the charges. So the prosecution will open his case by describing the charges to the accused, brought before the accused, and stating by what evidence that he proposes to prove the guilt of the accused. So prosecution will be asked, what is the basis of evidence by which you want to prove the guilt of the accused? So prima facie thing is being done by the court over here. And if on prima facie inquiry the court finds that there is nothing or there is no base of proceeding against the accused, then under section 227, discharge of the accused will be done. So if upon consideration of the record of the case and the documents which have been submitted therewith, and after hearing the submissions of the accused, so accused will be heard prima facie over here, and prosecution will also be heard in this behalf. Both of them will be given an opportunity here. The judge considers that there is no sufficient ground, there is nothing at all to proceed against the accused, he shall at once discharge the accused and record his reasons for doing so. So the judge has discharged the accused. Remember that here framing of charges has not yet been done. Trial has not been done. It is pre-trial, because till now no trial has been done. But the judge when he has prima facie, I told you before framing of charges, one opportunity will be given to the prosecution as well as to the defense, as well to the accused as well, uh, and he will be heard prima facie, so that the judge could apply his mind that whether it is a false case in which he is being fabricated, or there is some evidence, prima facie evidence on which we should proceed with this case. So if nothing of that sort is found, and it is some frivolous complaints being made or something allegations being made, and the judge finds no ground for proceeding, he will discharge the accused. So even before, so there are two things which are there in criminal trials. First word is discharge and the other is acquittal. Acquittal is the last stage after trial of the case. So whenever there is a judgment which is delivered, I told you, when trial will be begun with framing of charges, and net result of a criminal trial will be either it is going to be conviction or it is going to be acquittal. Conviction, you see that the guilt of the accused was proved, and that is why he is convicted for any kind of imprisonment or whatever penalty has been given on, but he's been convicted. Acquittal means that the entire trial was conducted, there was nothing found against the accused, and with full regards, like we say, baizat bari karna. So after full consideration of this case, he has now been acquitted. So nothing was found against him. In discharge, no trial has begun, no framing of charges has yet been done, and the person has been discharged. Okay, so in discharge, if later on, say for example, a person has been discharged in a sessions trial, and if later on some evidence is found against him by the investigating officer, and on based on that evidence, later on again there are some charges levied against the accused, he can again be tried. After a person has been acquitted, after the full trial has taken place, you see double jeopardy principle will apply, and the person cannot be uh, tried again for the same offense. But once a person has been discharged, he can still be tried. Why? Because till now no trial has been initiated. Yes, so it is discharged under section 227, which can be done by a sessions court. And after this will come now, because say for example, the court finds, or the judge finds, or the magistrate, or whatever the court, sessions court finds that there is nothing to discharge the accused and we should further proceed with the case. Now will come section 228, which is framing of charges in a criminal trial. And after framing of charges, the next stage will become, now trial has actually begun after framing of charges. So from this stage, the trial will begin. So you see, I've already told you that in this entire justice delivery system, what I feel that is the most tedious and the most difficult task is of framing of charges. So here, when framing of charges is being done, the judge has to consider and hear both the parties in prima facie. Both the parties will be heard, and if the judge is of the opinion that there is ground for presuming that the accused has committed an offense, so if there are grounds wherein the judge now thinks that there is sufficient evidence, or there is some grounds that we should proceed with the case, then he should go ahead with the framing of charges. And that too, say for example, if judge, when a sessions court is listening to the case and the charges, when he's going to frame the charges, again he's going to see that whether the charges which he's going to frame is exclusively triable by him. If he finds that the trial is not to be exclusively done by him, he will again send back the file to the proper court by which trial has to be done. So the judge will proceed with the framing of charges. So if the judge is convinced that the case is exclusively triable by the sessions court, he shall frame in writing a charge against the accused. So charges are always framed in writing. Okay, but if the sessions court is of the opinion that it is a case which is not exclusively triable by it, then the session court may frame charge against the accused, and by order transfer the same to be tried by the CGM or any other magistrate. So if he thinks that this is a case which need not be tried by us, so he will frame the charge and then he will forward the file to the proper court, be it the Chief Judicial Magistrate, or be it you could say the magistrate class 2 or class 1, whichever the competent court is. Then he will not proceed with the trial. So you see, even the sessions court or any any court, many a times, now this I'm talking of the hierarchy, wherein the sessions court has come while framing of charges, they have come to the conclusion that they are not fit enough to proceed with the trial of the case, and the case should be better taken up by the lower judiciary. Similarly, this circumstance could arrive with the lower judicial officer as well, that wherein he has started with framing of charges, and while he is framing those charges, he comes to realize that this is a case which is not fit to be tried by him. This is a case which is to be tried exclusively by Chief Judicial Magistrate or trial by Sessions Court. At that moment, the moment he realizes that charges are grievous against him, he is going to stop it. He is not going to frame the charge. He is going to proceed with committal of the case to the proper court. So this could happen with any court, be it the sessions court or be it the lower court, that circumstances might arise that while they are in the middle of their work, they realize that this case they are not going to power to take up. So they are going to strictly follow what has been written in IPC, case trial by, so trial, they will never proceed to the trial, or in fact, they can stop with the framing of the charges as well and send the file to the proper court, which would have taken the trial of the case. And where the judge frames any charges under clause B, where he thinks that he is competent to take up the case, the charge shall be read and explained to the accused there and there. Very important. So whenever charges are framed, it is important to read out what charges have been framed against the accused, and the accused should know that what is the accusation, what are the allegations against him under section 228. Then when the charges are being read over to the accused, maybe the accused pleads guilty on that very stage only. The moment the charges are read over to him under section 229, he may be convicted. So there could be conviction on plea of guilty. Say for example, the accused admits his guilt. He says that he does not claim to be tried. He has committed the offense, and then there could be conviction under section 229 on the pleading of guilty by the accused person. Say for example, the accused does not plead guilty and he says that I want to be tried, then will start the trial of the case will start then. Then what will happen is that if he does not plead guilty, then date for calling of prosecution evidence will be given. So next will be a date for prosecution evidence will be given. If the accused refuses to plead or does not plead or claims to be tried, then judge shall fix a date for the examination of the witness, and may on the application of the prosecution issue any process. So if he wants to compel any person to come to the court of law, any warrant to be issued, any other document to be produced, that kind of process will be sensitized by the judicial magistrate, because now the trial has to begin. So any person who is required in the court, any evidence, any person who is in the control of any kind of evidence which might be required by the court will direct that person to come to the court with that evidence. Then the next stage will be evidence for prosecution. So after the date has been fixed for evidence of prosecution, now will actually start the evidence for prosecution. So on the date so fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution. So now the prosecution is going to lead the case, and the judge may, in its discretion, permit the cross-examination of any witness. So any witness, any cross-examination might be allowed by the judge if he thinks fit. If he thinks that okay, a person has come from the side of the prosecution and he thinks that his cross should not be done right now, some time should be given to the other person, the judge can stop that thing over here only, and he can defer the date for the cross-examination to any other further date. Okay. So when the evidence of prosecution is been taken, and after examining the accused and hearing the prosecution and also hearing the defense on the point, the judge considers that there is no evidence that the accused committed the offense, the judge shall record an order of acquittal. So earlier we found that the judge has the power to, session judge had the power to give discharge under section 227 of CRPC. Here in section 232, the judge, after hearing the prosecution and also giving an opportunity to the defense, if the judge thinks that there is no crime which has been committed, then acquittal could be given under section 232. So the person could be acquitted under section 232. Then if such is not the circumstance, then entering upon defense, complete defense shall be allowed to be entered into. So when the accused is not acquitted under section 232, so either the judge can acquit the accused under section 232, but if it is not the case wherein the accused has not been acquitted, then obviously the defense will be given a chance to completely present their case. So entering upon defense could be done when the accused is not acquitted under 232. He shall be called upon to enter into his defense and adduce and to lead any evidence. Now defense evidence will also be taken. He may have whatever he may have in his support, he can lead that evidence. And if the accused if the defense also wants to compel any process, maybe he wants attendance of some person in the court, or he wants some document to be produced in the courts, like a chance was given to the prosecution, now complete chance will be given to the defense to sensitize for issuing of any process in the form of production of any document or anything or any person. That can be done by the defense as well. Same chance will be given to the defense as well. So once entering upon defense has been done, then will come the stage of arguments, which is section 234 of CRPC. So when the examination of the witness, if any, for the defense is complete. So when the examination of witness, if defense has leaded any kind of defense witness, after that it is complete, the prosecutor shall sum up his case. So when the hearing has been done from the side of the prosecution, now an equal opportunity has been given to the defense as well to present his case. Both the parties have been given a chance to present their case. Now the summing up of the case will be done by the prosecution first. So you see, whenever any next stage is being moved on, always and always priority is being given to the prosecution. So here prosecution will now wind up their case, sum up his case, and the accused shall be entitled to reply. One last time after the argument, in this arguments, the accused or the defense counsel shall be allowed to reply on their point. And then finally will come, I told you, when this entire trial has begun, now a fair chance has been given to the prosecution to lead their evidence, and to the defense also a chance has been given to lead the evidence from their side. So now will come the final stage, which is the judgment stage is concerned. And here the entire trial has now taken session, trial has now completed, and now finally they will have the judgment. This judgment could be either in the form of acquittal or it could be in the form of conviction. And you will find that the trial will end over here, and now the judge will finally pronounce the judgment. After hearing the arguments and points of law, the judge shall give a judgment in the case. If the accused is convicted, the judge shall, unless he proceeds in accordance with the provision, hear the accused on the question of sentence. So whenever the judge is pronouncing his judgment in the open court, then one last hearing on the judgment, on the amount of sentence also will be given to the defense. If they want to say anything, last word will again be heard from their side. And say, for example, while the court has decided to convict the accused now, so once the case has now decided to convict the accused, if there is any you could see if there is any previous conviction of that accused, that will also be considered by the court. So in case there is an accused who is a habitual offender, who has committed an offense earlier also of the same tune or some other offense, and now he has been convicted second time for any other offense, then obviously the punishment which would, now here you see obviously that when the conviction is announced or prosecution is to be given, then you see that if it is a death sentence, up to life imprisonment could be given. So up to life imprisonment could mean 10 years also, it could mean 14 years also, or it could actually mean 7 years. Or so how much sentence has to be awarded, we all see that in IPC lot of variation is given. Okay, so when this variation is given, how to determine that whether the judge should keep his punishment on the lower side, or the judges should imply or should be more towards giving the punishment on the higher side, will completely depend on the accused person here, or the set of circumstances in which the offense was committed. If the offense is of a graver nature, or maybe or maybe the offender is a habitual offender, then in that case obviously the maximum tune of punishment will always be awarded. But if the person who has been given this sentence has done the offense for the first time, or all the subordinating circumstances, surrounding circumstances, you could say, were such that the punishment of the highest order should not be given. So that those things the judges do consider while passing their conviction, or while passing their sentence orders. So judges will consider that, and might be they will lessen the punishment by 2 years, or maybe by even 4 years or 5 years also, looking at the circumstances. So that will be done by the judge. And this is how we proceed with the sessions trial. Uh, then I wanted to take you to this. There is a judgment which I wanted to. I forgot mentioning it in the slide. So there was this judgment, State versus A. Arun Kumar. This is a Supreme Court judgment, 2015 judgment, wherein the Supreme Court has laid down elaborate principles that the judge, while considering the question, especially with regard to the sessions trial, in which the court has said the judge, while considering the question of framing of charges under section 227 of CRPC, has the undoubted power to shift the way on the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. The test to determine prima facie case would depend upon the facts of each case. So you will find that whenever trials are being considered, the utmost importance is being given to the facts of the case. So that will also be considered. And in the judgment, the materials placed before the court disclose grave suspicion against the accused, which has not been properly explained. The court will be fully justified in framing a charge and proceeding with the trial. So you will find, depending upon the set of circumstances or set of facts of the case, the court will always consider the materials which are there before the court, and if they find that there is grave suspicion, they will always proceed with framing of charges. And if you find that there is no suspicion, or there is less suspicion, they will be in favor of the accused, and they will discharge the accused. But as far as any kind of suspicion is concerned, they will not let it go unanswered, and they will proceed with the framing of charges. So you see this, when we have done this section, this 225 to section 237, in fact, deals with the trial of sessions cases, and then will come the trial of warrant cases, which will start from section 238. So in warrant cases, we will find that again there is further bifurcation. Cases which have been instituted on a police report, first we will find, and then B, cases otherwise than on a police report. So those cases in which warrant trial has been proceeded upon a police report, in that case what will be done is that before the warrant trial is initiated under section 238, there will be seen that compliance with section 207 is being done. So when in any warrant case instituted on a police report, the accused appears or is brought before a magistrate, at the commencement of trial the magistrate shall satisfy himself that he has complied with the provision of section 207, and that the accused knows what charges have been levied upon, what charges have been leveled upon him. Okay, and section 239 says when accused shall be discharged. See, when we started with the sessions trial, we've studied that before charges were being framed, if the judge found that there are no grounds for proceeding against the accused, they shall discharge the accused. Similarly, in warrant trial also, you will find that discharge can be done under section 239 of CRPC. So if upon considering the police report, so police report Challan sheet, charge sheet was submitted under section 173, and this is a case, warrant trial case, which has been instituted upon a police report, and the other trial with regard to wherein the case has been instituted otherwise than on police report. So in a police report case, first will be that when the case has come before the magistrate, then he will see whether there is ground for proceeding against the accused like was being done in a sessions trial, and if he finds that there is no ground for proceeding against the accused, then at once the accused shall be discharged. So if upon considering the police report and the other documents which have been annexed under section 173 and making such examination as is fit after the you could see prima facie examination, if any of the accused, the magistrate thinks that necessary, after giving the prosecution and accused an opportunity, see, whenever discharge is being done, another mandate is that prima facie hearing shall not only be given to the prosecution but to the defense as well, that is to the accused as well. So if after hearing both of them opportunity of being heard, the magistrate considers that the charge against the accused to be groundless, so there is no base for proceeding against the accused person, so the magistrate can then can let go that person and discharge that person. And here again you will find that before framing of charges, like in sessions trial, in warrant trials also, discharge is being done before framing of charges. Once the charges have been framed, once the trial has begun, after the trial will be completed, then there will be either acquittal or conviction in this case also. So here it is, discharge can be done. So if the court does not find, if the in the warrant trial the court does not find that the person should be discharged and there are substantial evidence against him and that they should proceed with the case, then the next step, like in session trial under section 240, framing of charges will be done. So in a warrant trial, charge sheet has come. I told you when charge sheet will be filed, and after that also until charges have been framed, trial has not yet begun. So you will find that the stage of discharge, be it any kind of trial, will be pre-trial stage only. Discharge is pre-trial stage. After discharge, the very next following stage will be framing of charges, and from here the trial is going to begin. So if anybody asks to discharge, it is always a pre-trial phase. So under section 240, if there is evidence to proceed against the accused, framing of charges will be done. So if upon consideration, examination, hearing, the magistrate is of the opinion that there is ground for presuming that the accused has committed the offence which has been triable under this chapter, the magistrate is competent to try. So obviously magistrate is also going to check his competency every time the magistrate is going to frame the charges, every time the magistrate is going to take cognizance, he is always going to check, give a reality check to his competency as well. So he is going to proceed with any particular case. See, rule of law is what applies. So for example, in any circumstance, if they find defect in their own jurisdiction, if they find that this is an offence which is not triable by them, if they find that this is something of which they are not competent to take cognizance, they will stop there only. So if they think that they are competent, then they will proceed with the framing of charges in writing, formal framing of charges. I told you, framing of charges is always being done in writing. So they will write down the charges and proceed against the accused. And once charges have been framed, like earlier said, here also the same thing is going to apply. Then once the charges have been framed, then the charges shall be read over to the accused person, and the accused person shall be asked whether he claims to plead guilty or he claims to be tried. So there could be two circumstances when the accused has been charged with any kind of offence by the judge. Then if he pleads guilty, then what will be done is conviction on plea of guilty. If he does not plead guilty and he claims to be tried, then his trial will become. And again, in a similar manner like in sessions trial, here also evidence for prosecution shall be taken first, and then evidence for defense shall be taken. So for evidence for prosecution, a date shall be fixed by the magistrate, and the magistrate shall go on to examine the prosecution witness first on the date which has been fixed, And if the prosecution wants to compel attendance of any person, wants to issue any kind of process in the form of warrant or summoning of any person, that will be done by the order of the court. So the magistrate may, on application of the prosecution, issue a summons to any of the witness or direct any person to produce any document or anything which is required by the prosecution. That can be done. So on the dates of fixed, the magistrate shall produce to take all such evidence as will be produced in support of the prosecution. So every evidence which is there in support of the prosecution will be taken. And then will come the stage of section 243, which is evidence for defense. Now defense will enter into any evidence. If they want to lead, they will lead their evidence from their side. If they also want to compel any person to come to the court of law through summons, or the defense also wants to production of any kind of document or any other thing, that can be done through the order of the court again. Then this is the procedure which is followed in case which has been instituted on a police report. In cases instituted otherwise than a police report, in case of complaint cases, what will be done is directly evidence for in this cases for evidences, evidence for prosecution will be there, direct stage for prosecution will be there in cases instituted otherwise than on police report. So when in any warrant case instituted otherwise than on a police report, the accused has now appeared before the court or is brought before the court, the magistrate shall proceed to hear the prosecution and take all the evidence which was which he has brought along with him. And if upon hearing the evidence thereof under section 244, the magistrate considers for reasons to be recorded that the accused has been made out, which some accusation has been made out against the accused, which would warrant his conviction, which would not warrant his conviction, the magistrate can discharge him also. So there could be discharge in this case also. And if not discharge, then what will be done is the evidence for defense will be taken. Similar thing will be there. So if the accused is not discharged, then the evidence for defense will be laid down. And here you will find that the court will not formally, if when the such evidence has been taken or any previous stage of the case, the magistrate is of the opinion that there is ground for presuming that the accused has committed, no discharge is there, there ground for presuming that the accused has committed the offense, the magistrate in which he is competent to try, then could be adequately punished by him. He shall frame a charge in writing against the accused. So he shall frame the charges. The charge shall then be again read over to him, and he shall be asked whether he claims to be plead guilty. So this shall be done in a very in different, this could you to say steps. This will be again done. If the accused pleads guilty, then he shall be convicted. If he does not plead guilty, then he would be asked to bring his defense evidence. And once he has brought his defense evidence, then again will come the stage of the judgment, wherein acquittal or conviction would be given by the court. If the person is found guilty, then he will be convicted. If the prosecution was not able to prove to the satisfaction of the court that there is any ground on which the accused should be given punishment, then he shall be acquitted. So likewise in this warrant trial, there are some other this also added things also, which I'm not going to discuss here, because we are going to focus mainly upon the procedural aspect of the trial of various cases. Summary, these provisions we are not going to discuss here. But the very important thing to be kept in mind while proceeding with the sessions trial or while proceeding with the warrant trial is that the provisions of section 207, or if it is a sessions case, even section 208, they are very, very important, wherein supply of copy of FIR or supply of copy of complaint or other such statement against the accused which are there should be there is a mandate that they have to be supplied to the accused. See now you are leveling charges against the accused. If you're leveling any kind of charge against the accused, it is important that the accused should know that what is there, what substance is there against him till now. So it is very important to comply with provisions of section 207 and 208 of CRPC whenever we start with the trial part. So after the warrant trial, the next will come the summons trial, which is section 251 to section 259 of CRPC. So in this summons trial, you will see that formal framing of charges will not be there, and you will see the procedures are more done in a fastened manner in comparison to the warrant cases, because in warrant cases you see they were of more serious nature, and summons cases are comparatively of less serious nature. So in a trial of summons cases, substance of acquisition, when in a summons case the accused appears, so whenever there is a summons case and the accused is brought before the magistrate, the particulars on which against which whatever allegations against him are there shall be stated to him, and he will be directly asked whether he pleads guilty or he wants to make any defense. But it shall never be necessary for a court to frame any formal charge in writing in a summons case, which was required in a warrant case. and sessions trial always it is required, it goes without saying. But in a summons case, I told you the procedures are not going to be very technical or very strict enough. So here there is no obligation on the judge to frame charges formally. He shall directly ask whether you claim to be tried or you want to plead guilty. If he pleads guilty, again under section 252, conviction will be there. But if the accused says that he does not plead guilty, conviction, if he says that he does not plead guilty, then he can be tried in a fastened manner, not as elaborate procedure as were done earlier. So conviction on plea of guilty in absence of accused in petty cases. The next section says that wherein a summons has been issued under section 206 and the accused desires to plead guilty to the charge without appearing before the magistrate. So it might be that it is a very petty case, small case, summons case was there, small case was there, and even without himself coming to the court of law, he has sent his advocate, the accused has sent his advocate, where the through the advocate he has agreed to accept his guilt. Then just by levying the specified fine in the summons or whatever the court finds, the punishment will be levied upon him. So the magistrate may, in his discretion, convict the accused in his absence. So though the accused is not there, he has sent his representative in the form of his counsel. Then the magistrate shall plead on his pleading of guilty. The magistrate can sentence him to pay the fine specified in the summons and the amount transmitted by the accused. So whenever summons were being sent for the case, in that summons only it was written already that if you claim to be tried, you can come. If you want to plead guilty through some other person also, you can send that person. If you plead guilty, this much of fine will be levied on you. And if that person has pleaded guilty through the officer of the through some officer or sorry through some through his counsel, then that fine shall be imposed upon him. So if the magistrate does not convict the accused under section 252 or 253, wherein he has either pleaded guilty in person, so 252 relates to plea of guilty in person and 253 pleads guilty in his absence. So if both the circumstances are not there and the accused has not pleaded guilty, either in case personally or through his in petty cases, in petty cases through some other person is not pleaded guilty, then what will be done? If the magistrate does not convict the accused under 252 or 253, the magistrate shall proceed to hear the prosecution and take all such evidence as will produce in support of the prosecution. Then magistrate shall allow the prosecution to plead his evidence. If magistrate wants to issue any summons to any particular witness, that will be done. Then after that, if there is something which is found against this, then finally judgment will be written in the form of acquittal or conviction will be there under section 255. So finally judgment will be delivered of acquittal. So once the hearing has been done, by the prosecution, then directly this judgment will be there of acquittal or conviction, like in other cases. Then, with regard to trial of summons cases, also there are certain sundry provisions for which we are not going to go into the intricacies as such, because they are something which is apart from the procedure, the subordinating circumstances which could be there. So, okay, at any point of time during this entering of defense witness there, or when the statement of accused is, there are two, three important things which have to be remembered, which I wish to tell you is this. Okay, whenever this trial is being conducted, during the conduct of the trial procedure, at after the this at any time during this trial process, statements of the accused could be taken by the judge under section 313, which is a very important provision, wherein it has been found that the judges directly ask the accused, and their statements are recorded under section 30313, sorry, of CRPC. And the accused at that point says his realities and conditions of the case, and you will find that many a times this section 313 is resorted to by the judges in even informally also asking the accused, when they take him to his retiring room sometimes, and they ask him that, tell me what is the real case. So apart from his pleading guilty, okay, wherein he will be convicted of the offense, primarily he will be asked. So there are two things, two options which are being given. There are two options which are being given to the accused every time, that whether he wants to plead guilty or he claims to be tried. So if he pleads guilty, obviously conviction will be there, or if he claims to be tried, then obviously the trial will begin. But in between this entire trial process, at any a times, practically what has been seen, many a times the accused is being even called not in the court, many a times to his retiring room also, and where the judge is keen to know that what actually happened. So judge will not, maybe he will not convict the accused on the basis of that person, but he will ask him that, okay, from this prima facie case I could easily make out that you have committed the crime. Will you tell me the facts of the case, that what happened, what are the realities, what are your conditions in life, so as to know what actually happened. So this is a very power of very big resort, which is given to the magistrate. So the accused at any point says that his or her realities and conditions of the case, anything recording during the statement can be utilized against the person in question at any later stage. So this could be done in writing by the court, and this could be done at any time during the entire trial. Section 313 of CRPC, very important provision. And one more section which I wanted to take you through is this. Yes. Okay. So this is the important power being given to the court at any time to ask uh, the accused informally and formally. Informally also they ask, and it can be contained formally. So many a times judges do write it down in 313 statements, and many a times they do not even write it down, but informally they can ask under this provision, so nobody is going to stop them asking the accused what was the real set of facts and circumstances in the given case in hand. So this was all about summons cases. And finally there is this speedy provision, speedy trial being given in this some summary cases as well. trial of summary cases could be done. So this trial power of summarily trying the cases is being given to this CGM or to Metropolitan Magistrate or any other magistrate specifically empowered to do so. So these are depending upon the High Court rules to which officer they have given the power to summarily try cases of offences not punishable with death or not with a fine or imprisonment not exceeding 2 years. So those summary offences wherein offences being committed by the accused for which punishment is less than 2 years, they can be summarily tried. Now, why summary trial will be there? Here, the procedures would be even more fastened up in comparison to summons trial. So this summary trial is, in fact, you could say speedy trial would be there. So this is the last kind of trial which is there in the four trials that we have discussed. We started from sessions trial, then the warrant trial. Warrant trial also cases instituted upon police report, and other than police report, then was the summon trial, and then comes the summary trial. And like otherwise it happens that maybe the magistrate has accepted the case to be tried summarily, and while he is trying the case he comes to the conclusion that the case should not be tried summarily and some other trial should take place, so he's going to stop there and then. So you will find in CRPC every time whenever magistrate finds deficient in their own powers to try or proceed with the case, they are going to stop at that stage. So say for example it was a case wherein the magistrate had taken it for summarily trying the case, but while trying the case he comes to the conclusion that he cannot proceed with the case, so he's going to stop at that very moment. So what is the procedure for summary trials? In trials under the chapter of summary trials, the procedure specified in the code for the trial of summons cases shall be followed. So most of the times procedure of summons cases, summons cases will only be followed, which is in a much faster manner than the other trial. So how the record of summary trial? In every case tried summary, the magistrate shall enter in a book to be kept for that particular all the details of the cases which are being tried summarily, and every detail regarding the case. When was the case reported, when did the complaint given, was the commission of the offence, when was the case reported, where the accused resides. So there's a diary in which the magistrate is going to keep a record of the cases which is going to try summarily, of the commission of the offence, report or the complaint copy, or who was the complainant, who is the accused, what is the resident's name, whatever could be taken out of the accused, that will be written, and whatever they found in this case, and whatever judgment or sentence they have given or any other final order, they will write it down in this book. So in every case tried summarily in which the accused does not plead guilty, so wherein the trial took place in accordance with summary trials, the magistrate is duty bound to record the substance of the evidence and judgment containing a brief statement for reasons for his findings. So whatever he finds, he is going to write a brief statement for summary cases. So this is how, and this summary trials basically is contained from section 260 to section 265. So the trials entire process, you will find them more or less in 41 sections you could see, which will initially start from section 225 of CRPC, and they will end with summary trials, which is section 265 of CRPC. So it is a set of somewhere around 40 to 41 sections, and this is basically the entire, you could say, the trial processes, and the within this entire sections of trial processes, the actual trial, there could be some sections of pre-trial as well, as I've told you, till the framing of charges, the pre-trial stages will be there. After that, trial will be there, and finally the judgment will be there. After the judgment, there is this third stage also, which is also known as the post-trial stage, and this post-trial stage could be in the form of making appeals to the court, wherein the parties are dissatisfied with the judgment of the court, or could be any kind of revisional applications which are being made to the court, or any references being given to the court. So other options which are there post trial could also be taken care, could also be there in the third stage of this. And with this, I think we are going to end over here.
Thank you so much, ma'am. This is really an informative session. Ma'am, we have few questions regarding the session. First one is the add to stage. First one is the what is the role of prosecutor in a criminal case and how does it is differ from the defense lawyers advocate defense lawyers.
Prosecutor, you see in criminal trials, the entire edifice of proving the case lies on the shoulders of the prosecution only. If we say of defense witness, they just have to lead the preponderance in their favor that they have not committed the offense, but wholly you will see the responsibility of proving the guilt will lie on the prosecution, and their role in the case is much more elaborate, much more technical in comparison to the defense witness, because we as I've said you initially that we are depending on the adversarial system, wherein the entire this in our criminal justice system, the entire the responsibility will always lie on the prosecution, and less of this will lie on the defense.
Okay, ma'am. Thank you. Then another question is how does the criminal justice system handle cases involving juvenile offenders differently from adult offenders?
Yes, a very important question. In fact, I wish to mention this section 27 also of CRPC, wherein the section 27 of CRPC, wherein the normal courts, regular courts are not competent to try cases which are there with regard to juvenile offenders, or juvenile offenders are there, juvenile cases are there. With for them, separate courts are there which are dealing with these cases, and separate powers have been given to the court for dealing with such cases, juvenile cases.
Okay, ma'am. That's all, ma'am. Thank you so much for today's session. On behalf of entire Faculty of Law, Integral University, I heartily thank you for holding the session and it's such informative session, ma'am. Thank you so much.
Thank you so much. In fact, it was my privilege to be with you all today. Thank you so much.
Thank you.